Welcome, everyone, to our virtual symposium on the history and future of the Indian Child Welfare Act and implications for tribal sovereignty and Native family preservation. My name is Johanna Greason, and I'm an associate professor at the School of Social Policy and Practice at the University of Pennsylvania. I'm also the managing faculty director of the Field Center for Children's Policy, Practice, and Research. It is my honor to be moderating our timely and important discussion today on ICWA. Before introducing our esteemed panelists, I want to extend my thanks to the sponsors for this two-part symposium, including the Penn Carey Law School and their conference team, especially Naoshi Giles and Zoe Frakes, and our Field Center staff, Sarah Wash and Felicia Saunders, for all their hard work over the past months in planning and bringing us together for this event. As many of you know, the constitutionality of the Indian Child Welfare Act is in question after the Supreme Court heard arguments in HAALAND v. BRACKEEN at the beginning of November. This case involves a young child who is now 4 years old, referred to her by her initials YJR, whose mother is Navajo, and the white couple who seek to adopt her. The couple is challenging the law, which preferences adoption by a tribal family member when a child who is a member of a tribe or eligible for tribal membership is in state custody. The case raises questions of race, tribal sovereignty, family preservation, and equal protection, and commentators have noted the potentially far-reaching implications of a decision striking down ICWA. Considered by many to be the gold standard of child welfare practice, ICWA focuses on family preservation and recognizes the United States' abhorrent history of forcibly removing Native American children from their families. Our panelists today bring a wealth of expertise to this discussion from their work on the bench, as legal advocates, and as legal and social work scholars. Thank you to each of the panelists for joining us today. To submit a question to our panelists following the discussion, please use the Q&A feature found on the ribbon at the bottom of the window. Please keep your questions topical and appropriate. Anyone posting inappropriate language or content will be removed. We are also recording this virtual symposium. This webinar is offering CLE and CEU credits. If you're seeking CLE credit for today's event, please note that CLE codes will be presented twice per hour. Therefore, there will be 3 CLE codes. Write down these codes and enter them on your digital evaluation form once the event is over. The evaluation form is mandatory to receive CLE credits. Please find the link to the evaluation form in the chat. The first CLE password is Supreme. It is now my pleasure to introduce our 4 panelists. Claudette Grinnell-Davis is an assistant professor of social work at the Anne and Henry Zarrow School of Social Work at the University of Oklahoma, Tulsa Campus. They earned a PhD in social work and psychology from the University of Michigan and an MSW in interpersonal practice from Western Michigan University. Dr. Grinnell-Davis is currently the principal investigator of the Honoring Indigenous Families Project, a Robert Wood Johnson Foundation-funded community research collaboration studying the implementation and outcomes of the 2015 expansion of the Nebraska Indian Child Welfare Act. Their most recent research has focused on outcomes for children identified as American Indian or Alaskan Native in national child welfare data, American Indian children neglect and the American social safety net, decolonizing methodologies in child welfare research, and the full incorporation of lived system expertise as a care leaver and care recipient into child welfare research and evaluation. Matthew Fletcher is the Harry Burns Hutchins Collegiate Professor of Law at the University of Michigan Law School. He teaches and writes in the areas of federal Indian law, American Indian tribal law, legal and political philosophy, constitutional law, federal courts, and legal ethics. And he sits as the Chief Justice and Appellate Judge for numerous Indian tribes. He is a member of the Grand Traverse Band of Ottawa and Chippewa Indians. Professor Fletcher has worked as a staff attorney for 4 Indian tribes, and he previously sat on the judiciaries of 3 Indian tribes. He also served as a consultant to the Seneca Nation of Indians Court of Appeals. He was lead reporter for the American Law Institute Restatement of the Law of American Indians, completed in 2022. He has published articles in many law reviews. His Horn book, Federal Indian Law, was published in 2016, and his concise Horn book, Principles of Federal Indian Law, in 2017. Professor Fletcher is the primary editor and author of the leading law blog on American Indian law and policy, Turtle Talk. Wenona Singel is an associate professor of law at Michigan State University College of Law and the director of the Indigenous Law and Policy Center. She teaches courses in the fields of federal Indian law and natural resources law, and her research and publications address the development of tribal legal systems and tribal accountability for human rights. She served as deputy legal counsel for the Office of Michigan Governor Gretchen Whitmer from 2019 through 2021, advising Governor Whitmer on tribal state affairs. Professor Singel, an enrolled member of the Little Traverse Bay Bands of Odawa Indians, was the first tribal citizen in Michigan's history to hold that position. Her professional activities have included serving as the chief appellate justice and judge for 2 tribes. From 2006 to 2009, she served as president and board member of the Michigan Indian Judicial Association. Professor Singel received an AB from Harvard College and a JD from Harvard Law School. Judge William Thorne Jr., a Pomokos Miwok Indian from Northern California, was appointed to the Utah Court of Appeals in 2000. He retired in 2013. He was previously a judge in the Third Circuit Court for 8 years and then served in the Third District Court for 6 years. Judge Thorne received a BA from the University of Santa Clara in 1974 and a JD from Stanford Law School in 1977. Judge Thorne has served for over 34 years as a tribal court judge in 12 states. He is the former president and current vice president of the National Indian Justice Center, a former member of the board of directors for National CASA, a member of the board for the Center of the Study of Social Policy, a member of the Advisory Council for the Capacity Building Center for Tribes of the U.S. Children's Bureau, and a member of the Advisory Board for the National Child Welfare Workforce Initiative. In 2016, the National Center for State Courts recognized Judge Thorne with their Distinguished Service Award, and in 2021, the National American Indian Court Judges Association honored Judge Thorne with a Lifetime Achievement Award. Okay, now that we've gotten the introductions and housekeeping out of the way, we are going to turn to our panel with some prepared questions that we've asked them all to consider. So the first question, on November 9th, the Supreme Court heard 3 hours and 12 minutes of oral arguments in HAALAND v. BRACKEEN. The case challenges the constitutionality of the Indian Child Welfare Act. Can we start off by highlighting some of the key issues discussed during this hearing? I'd like to start with Wenona.
Hi, Annie Bourgeois. Thank you so much for the opportunity to participate, and I'm really honored to be here. So, of course, first I'd like to give a little bit of background on ICWA, if I may, because it was passed because nearly a third of Native children were being removed from their homes and their tribes, and 90% of them were being placed with non-Indian homes. And so Congress passed the statute ICWA in 1978. And so we still have dramatic overrepresentation of Native children in the child welfare system, with Native children being represented in state foster care at a rate 2.5 times their presence in the general population. And so in spite of the fact that there continues to be a strong need for both the substantive and procedural protections that ICWA offers, we have a variety of parties that have been seeking to challenge ICWA. And so the BRACKEEN case represents a very broad-based, multi-pronged effort to challenge the constitutionality and lawfulness of the statute. And so during the oral arguments that we heard on November 9th, we heard a number of issues addressed. And so first off, I want to acknowledge that the standing of the parties is certainly at issue in terms of the fact that redressability and injury in fact are both at issue in the case. And so it is certainly possible that the case may be dismissed for lack of standing without the court actually reaching the merits of the substantive arguments. But if, however, the court does reach the merits of the substantive arguments, those are varied. And so they include, for example, a challenge that Congress did not have authority to pass ICWA. And that requires assessing the power of Congress in Indian affairs, which is based on the plenary power doctrine, and also the power of Congress in Indian affairs arises in part out of the Constitution's Indian Commerce Clause, which vests Congress with the authority to regulate commerce with the Indian nations. And a contemporaneous dictionary definition of commerce would include intercourse, which at the time would have included all variety of interactions with tribes, not purely trade with tribes. So one issue, of course, is that the court will have an opportunity, if it reaches the merits of the case, to address its existing jurisprudence on the nature of Congress's authority in Indian affairs. And it's potentially, if that is narrowed, if the doctrine is narrowed, it could have impacts in other areas of legislation impacting Indian affairs far beyond the child welfare context. A different and second issue that's also presented in the case is equal protection. And so the challengers to the statute argue that the statute includes provisions that are based on race discrimination. However, in Indian law, we have a Supreme Court precedent called Morton v. Mankari, which clarifies that legislation dealing with tribes and Indian affairs is based on their unique political status. It's not based on their racial status, but rather based on their government-to-government relationship with the United States. And that Congress's legislation in Indian affairs, when it's related to tribes and Indians and their unique political status, is authorized as long as it's rationally tied to Congress's unique obligation toward Indian tribes. So as long as Congress is fulfilling its trust responsibility toward tribes, then it's can satisfy that rational basis test. So the parties will have certainly argued that, for example, the third preference, placement preference in ICWA, that is race-based rather than based on the political status of tribes. And again, if the court changes its jurisprudence on this and, for example, modifies the application of Morton v. Mankari's rule, and that could certainly introduce a new wave of litigation that could impact Indian affairs far beyond the child welfare context as well, allowing other litigants to bring race-based challenges to legislation passed in Indian affairs. And then in addition, there were other arguments. I'm not going to go into a lot of detail with them, but they also include a anti-commandeering argument. And so there's an argument that Congress was commandeering the states in passing ICWA, which imposes obligations, both procedural and substantive, on state courts and state actors. However, this is similar to the principle of the supremacy clause and preemption, that federal law prevails over conflicting state law and can be applied in the states. And then in addition, there's a non-delegation argument related to which the parties challenging ICWA claim is based on the fact that ICWA allows tribes to develop their own preferences. However, interestingly, at the oral argument, there was no substantive discussion of the non-delegation arguments of the parties challenging ICWA. And so that's not the focus of the court at this time. So that's a brief overview of the issues.
That was amazing. Thank you. I'd like to see if any of our other panelists would like to add to Wenona's discussion.
I have a much more mundane approach. I think Professor is absolutely right about the law, but this is really a challenge to the existence of tribes and tribal sovereignty, masked under the pretense of what's best for Indian children. There's very little discussion about what's best for children. People ignored the fact that Texas is under a federal court order because their child welfare system is inadequate. It has been found to be inadequate. And yet they're arguing that Texas and Texas law should apply rather than what national organizations and 20-some states rather have said is the gold standard for how children should be taken care of. So this is really a blatant challenge to the existence of tribes, not just a discussion and a dispute about what's best for children.
Thank you, Judge Thorne. So can anyone talk a little bit more about the third placement preference and what that means in this case?
I can go ahead and discuss that a little bit, not necessarily legally, although I have questions about the legal assertion of the third preference. And there are orders of placement in ICWA for practice, and those orders of placement are for children to be placed with kin first and foremost, then within the tribe and its own identified foster care placements, and then with other Indians. And here, this is where the third placement comes in that I have questions about, with other Indians who may be from other tribes before being placed out of that. Now, that said, the question is about whether third placement, if you place a child, and the example that came from the court is what purpose does it serve a tribe if a Seminole child is placed with in a Cherokee home? The fact is, the question in this is whether that third placement still also has to be a citizen of another tribe. The implication is that it does, which again then ties this to a political identity instead of a racial identity. And it is very complex. We can talk about the complexity of being Indian in the United States all day long. It's a cultural identity, a political identity, a historical identity. But even with the third placement, the notion is still you're placing somebody with a politically identified Indian family. And there are all sorts of good reasons for that. First of all, let's remember that a child's tribal membership does not transfer just because they're being cared for by somebody from another tribe. So if that Seminole child is placed with a Cherokee family member, they don't automatically become Cherokee. They stay Seminole. So that question about the political aspect in the third placement, it's still a political identification as far as placement goes. But that said, even though there's not the exact same history, there are various aspects of history that Indigenous people share across Turtle Island that may not be specific, but are shared. So for example, most people know about the Trail of Tears and the forced deportation of the 5 tribes of the Southeast. Many people do not know that the Potawatomi were forced to do a similar walk. And they call that one the Trail of Death. There is a shared history of cultural genocide there that cannot be denied. And at least with that, there is at least a shared experience of understanding what it means to attempt to be erased. And so you can talk about the third placement preference being racially based all along, but the reality is it's not. It's still a political appointment. And it's necessary, I think, as a part of essential identity to understand what has happened to Indian people in ways that continue to support justice for Indian people in its relationship with the federal government broadly.
Thank you, Claudette. So Wenona mentioned a previous case, Morton v. Mancari, that sets precedent about the political status of Indian tribes in the U.S. How do you see this as different than race, and what are the implications for equal protection? And this is question out to any of you.
I'm happy to try to answer that.
Hi, Matthew.
Hi, sorry I'm late.
That's okay. Yeah, that would be great. Are you going to hop in?
Sure. The Supreme Court actually answered this question in 1974. There's a really simple rule. So long as Congress is acting in a rational relationship to the fulfillment of the trust responsibility, the statute is valid, full stop. It's a really easy analysis. It's an analysis rooted in pretty extensive deference to Congress, which the Supreme Court until the 1970s always granted to Congress in Indian affairs, usually to the detriment of Indian people and tribal nations. But in 1974, the Supreme Court started seeing cases where Congress was acting to benefit tribal interests or to give preferences to Indian people. So they held in 1974 that if Congress does that, then so long as it is related in a rational way to the fulfillment of a trust obligation or the duty of protection of Indian tribes, that's the end of the analysis. And, the Supreme Court has been very supportive of that ruling. They might not like it as a policy matter, but throughout the rest of the 1970s, there were a series of cases where Indians and non-Indians and states challenged various acts of Congress or Indian treaties that provided treaty rights or other preferences or property interests to tribes and individual Indians. The Supreme Court more or less summarily said, nope, these all fit the Mancari test. There's nothing to see here. And they really haven't had a case like this until BRACKEEN, since the 1980s. So there really should be no argument here. So the Constitution, as Justice Gorsuch mentioned in oral argument, references only one ethnicity or race within its text explicitly, and that's Indian people. Indians not taxed, and Indian tribes. And it's a really simple reason why the Morton v. Mancari rule is a simple argument, because Congress has one race or ethnicity that it can legislate about, and it does it regularly. And if it does so in relation, rationally related to the duty of protection, then there's really nothing to discuss. What's of course frustrating about the BRACKEEN argument is that justices on the Supreme Court want to talk about the third placement preference, want to talk about the definition of Indian child to try to say, well, here are places where Congress is discriminating against non-Indians or creating a racial classification. And if they decide to vote and rule that one or more of these provisions is struck down, then really they're saying the Constitution itself is unconstitutional, which is just absurd. Of course, it's absurd. Luckily, the tribe's attorney, Ian Gershon-Gorn, pointed out throughout his portion of the argument that this is what lawyers will call a facial challenge to a federal statute. And what that means is that every potential application of that statute is unconstitutional. And so the strategy of pointing to a provision or two within the text of ICWA and saying, well, these might be applied in an unconstitutional matter is fatally flawed when you are bringing a facial challenge. The facial challenge test is, so long as there are possible applications of the statute that are constitutional, we are not going to strike the whole statute or even portions of the statute. And so we'll see where that goes. There's nothing rational about this case from day one, so we'll see how it plays out.
Thank you, Matthew. We're going to now move on to our second question, which is, what is your sense of the justices' reaction to the case and their focus in the oral arguments? Do you have a sense of which way individual justices may be leaning? And can you speak to areas that you wish had received more attention in the oral arguments? And let's stay with Matthew to begin with.
Happy to do it. Again, as I just said, this is a frustrating argument. The equal protection analysis, the federal government could have made a really easy argument pointing to the rule in Mancari, pointing to the text of the Constitution. Instead, the government hemmed and hawed, took these ridiculous hypotheticals that came from the conservative judges and said, well, those are really hard cases. I don't know how it would come out, but ICWA should be upheld. I mean, it was about as lame, and excuse me, lame is an incorrect term, but a weak argument as you can get. At least the tribe's attorney tried to focus the issue on the fact that this is a facial challenge and not a series of tests about hypotheticals or law exam questions. Similarly, the arguments on the 10th Amendment were frustrating because, again, the test is, does the state have an interest in child welfare or Indian affairs? And if so, is Congress dictating terms to the states? And the answer is plainly no. I mean, Congress is telling the states that here are federal rights that are created. The courts have to respect them and to enforce them. That's not commandeering. My sense is that there are 4 judges who would roundly affirm Indian law generally and the Indian Child Welfare Act. And there are 5 judges who, at least from the questions that they asked, the sense of, even their facial expressions, their own argument, and just the fact that they kept asking the same questions over and over and over again, questions rooted in logical fallacies and completely incorrect understandings of what the law is, indicates to me that they're looking for any avenue, any excuse whatsoever to strike all or parts of the Indian Child Welfare Act down. I think I'm going to reiterate what Judge Thorne said and what Judge Singel, Professor Singel, former Judge Singel said, that if any part of ICWA goes down, there are avenues to just strike down vast swaths of the Title 25 of the U.S. Code. I assure you that anybody who is defending somebody in federal state court now who is being charged with a crime in Indian country is watching this case carefully. If even one portion of ICWA goes down because of some sort of Indian status, Indian classification, racial classification argument, all of Indian country criminal jurisdiction is completely up for grabs. There'll be complete anarchy. And it's a question of, is this a court that is interested in applying the law, analyzing the law, or is it a court that wants to completely upset the whole system of government in Indian country? And I really don't know where this court is. And that's deeply frustrating aspect of this case.
Thank you, Matthew. So I'd like to open up this question to the other three panelists.
I think Matthew is absolutely correct, but I was most distressed by the fact that this is a challenge to ICWA, and yet there was virtually no discussion about what was best for those children. The fact that social science, research, all demonstrate that what ICWA is attempting to do, we really ought to be doing for all kids. These kids are not being disadvantaged. These kids may be the pilot program for what we should be doing for everybody else. But nobody discussed that. That's what, at least to me, unmasked the fact that this is more about a challenge to Indian status and tribal sovereignty than it is about what happens to those children.
And I want to follow that up with the commentary from the person of the state of Texas about active efforts, talking about how they have a standing in the case because of fiscal responsibilities. And I'm sitting here going, wait a minute, stop. Active efforts, when correctly implemented, are actually cheaper. If we think about active efforts as being a mechanism of supporting kinship, which is generally unpaid in the American child welfare system, which we can talk about the justice of that, but that's a different conversation. In general, kinship care is much cheaper to a state than non-relative foster care, which over and over and over again, and I'll bring that up a little bit further on in our set questions, was misrepresented as the main mechanism of practice for child welfare generally. And the bottom line is, you know, these are preposterous arguments. The one thing that I will say that I was encouraged by, and this is something that I have taught over and over again, because we had a situation within social work where somebody tried to push a document nationally that placed the American Association of Adoption Attorneys as equal stakeholders in any discussion related to Indian children, to which a group of us stood up and said, wait a minute, stop. No, adoption is not a right, whereas sovereignty is a right. And so this launched a whole conversation around the Hague Convention. I was really actually pleased to see Justice Sotomayor go straight for that as an assertion of sovereignty, because I do agree with Matthew and Bill. This is not about what's best for Indian kids. This is about the undermining of tribal self-governance and the right of tribes to call themselves sovereign and act as if they are sovereign. And the reality is, sovereigns have the right to protect their citizens, period. And to deny in various ways, which was tried, because the one plaintiff kept talking about wanting to relegate Indian power only to the reservation. What about tribes that don't have reservations per se, but have service areas? The one that comes immediately to my mind is the Ponca tribe of Nebraska, which has a 15-county service area, non-coterminous, but no actual reservation to speak of. And there are other tribes that are in that situation. So, you know, the idea that tribes only have sovereignty on the res is again a restriction of sovereignty. So I was really glad to see particularly Justice Sotomayor highlight that this is really about sovereignty. This isn't about anti-commandeering. This is really about sovereignty. That was the one thing that was encouraging to me from what I saw.
Thank you, Claudette. Matthew, is there something else you'd like to add?
Yeah, absolutely. So another frustrating aspect of the argument was, as Claudette pointed out, is, these are attorneys and justices who'd never handled a family law case in their lives. They have no idea what goes on. It was interesting to hear a couple of judges ask questions like, what does it really mean to do active efforts? How do best interests of the child apply here? And what was enormously frustrating is not a single party, not even the tribe's attorney, and perhaps just didn't have the opportunity, was willing to talk about what this case really is. It's about 3 non-Indian families who are fighting to take children from their biological relatives who happen to be Native in this case. That's what this case fundamentally is about. And there's a 4th case out there, which is even worse, a 2nd child that the BRACKEEN family wants to adopt, who they've never actually fostered that child before. And they won custody in the Texas Texas court system, even though they never had custody. They can adopt this child. So there are 3 of the 4 children that are at play in this Supreme Court case and in the Texas Supreme Court case that where a family court, a trial level court, applied the best interests of the child analysis and granted a win to non-Indians who are trying to keep children away from their biological relatives. And all of this is done, frankly, in accordance with the Indian Child Welfare Act. We don't like those outcomes, but the Indian Child Welfare Act incorporates this notion of the best interests of the child analysis. And when you have a state court system where the vast majority, there are hardly any tribal judges, Native judges in the state court system, hardly any people of color, relatively speaking, in the system. The best interests of the child analysis arose out of state court common law throughout the 20th century that privileged wealth, it privileged race, it privileged class. And Native people, even under the rules of the Indian Child Welfare Act, will still lose most of these cases because the best interests of the child analysis really is fundamentally a creature of colonialism. And that's what one of the many things that is incredibly frustrating about this case is this false perception that tribal status somehow gives a veto under the Indian Child Welfare Act to prevent families like this from adopting children. White families win these cases pretty regularly, and many times the tribes are on the side of the white families to adopt these children. This is not a zero-sum game. That is not obvious lines drawn here. And the court is, and the advocates on the other side are looking for an easy narrative, which will absolutely be a false narrative to try to come up with an analysis to strike down all or parts of ICWA under this kind of thing. There's no factual basis for any of this stuff. And one last thing, that 3rd placement preference that everybody spent so much time talking about, was so glad to see the tribe's attorney mention that there has not been a single decision in court about that 3rd placement preference. If it is applied, it's applied in cases where there's no contests, nobody's objecting to it, but it is so rare for the 3rd placement preference to apply at all. And it isn't even at issue in this case. The 3rd placement preference is nothing to do with any of the 4 children at play in this case.
Thank you, Matthew. So as a follow-up to this discussion and this question, I'm interested in hearing any of your reflections on whether or not you think the court considered how ICWA can mitigate trauma to children who are involved in removal proceedings, and if you feel like there was any recognition of the trauma of being removed from your family.
I think it was clear that the lawyers and the judges who were asking questions, that didn't even cross their mind. They're so used to this idea that social science embraced 40 years ago, that adoption was a solution. We know now that adoption is like a prosthetic. It's certainly better after amputation than nothing, But the best solution is keeping children with their families, not necessarily just nuclear families, but their extended family. So they grow up with a sense of belonging and expectation that these relationships will exist for a lifetime. The new research again that I think it was USA Today a couple of months ago, the failure rate out of public adoptions is a lot higher than people have deluded themselves into believing. That these children, their best interest really is to stay with extended family who will love them and be around them forever.
And this is part of a, I'm sorry, Wenona, I didn't mean to step past. I was going to say, and this is part of a broader national discussion we're having about adoption and child welfare generally, which is the notion that somehow adoption is a traumaless act. It's not. It's not traumaless for anybody, including, and there are some questions in terms of diagnosis about whether reactive attachment disorder is really a disorder or really if it's the trauma of the parent projected onto the child for the adoption process not going as easily as it has, or they think it should. I was really disturbed by the misuse of attachment in relationship to the adoptive parents. We are beginning to talk very explicitly in research now about indigenous models of attachment. My colleague Jessica Ulrich has written a wonderful article on relatedness models of connection around child welfare concerns explicitly. She published it in 2019. When we talk about our attachments as indigenous people, it's not just to people in these nuclear relationships. It's to land, it's to where we grew up. And that happens not even just when we're kids, but when we're adults. I'm a 53-year-old woman in the process of finding my own way home to my own people, having recently found out that I am Métis and what that means in my traditions. And the more that I learn what it means to be Métis, this gives me encouragement. It gives me an attachment to place and to people. And if this happens to me 53 years from down the road, it also happens to children and their extended families as well. And there is a trauma, no matter what, that comes from being disjointed from where you are from, no matter when in your life that happens. Go ahead, Wenona. Sorry.
Oh, thank you. That's all right. Thank you for your comments. Yeah, I just wanted to add that just as Matthew was saying, that this court does not have significant experience in the area of family law. It's also worth noting that two members of the court, Amy Coney Barrett and Chief Justice Roberts, are also adoptive parents. And they do not share the experience or perspective of being a member of a community or a member of a family that has intergenerational loss of children due to this cycle of colonization that our Native families have been subjected to for generations. And so they absolutely are not informed about the effects of the trauma of adoption and child separation of children from their families and culture and community. And I didn't hear any kind of insight into that. And we know that we have absolutely a cycle where families, including my own family, have experienced generation after generation of children being lost from the family due to adoption. And prior to that, generations of children being lost to their families due to forced attendance at Indian boarding schools. And then prior to that, we also have children being broken up from their families as a result of dispossession from their lands and territories, and through policies of other policies of forced removal and assimilation. They've all had a detrimental impact on the family, and this has had a cumulative, cyclical, ongoing, intergenerational impact on Native families. And this court is not at all sensitive to or even curious about asking questions about the importance of that.
And I would also add that disconnection has resulted in long downstream effects that affect other aspects of Indian governance and support. There is a white paper currently, an economic white paper on how the destruction of the buffalo herds of the Great High Plains ended up resulting in the economic deterioration of most of the tribes in the northern Great High Plains. I can't think of all of the authors right now, but one is Rob Gilazo at the University of Toronto. And it's had significant economic impact. That economic impact in turn affects the way tribes can self-govern downstream, because most people don't recognize that tribal governance, when it's funded through the federal government, is usually done piecemeal and to a much lesser extreme through block grants rather than discretionary funds that fund nearly everything else. So tribes already have to start from a funding position of scarcity in doing nearly anything from a governance perspective. And this includes tribal child welfare too. So there is so much that gets done and has been done, and we're still looking at these long downstream effects of dispossession in ways that we're not readily talking about in relationship to this work.
Thank you, Claudette. So before moving on to our next question, I would like to address a definition. ICWA is commonly referred to as the gold standard in child welfare. Wenona, can you educate us on what that means?
Yeah, I'm happy to provide some background on that. So yes, there are professionals that work on child welfare in the child welfare field, far beyond and including tribal communities and those who work on Indian child welfare who recognize that ICWA is the gold standard. And so there's multiple reasons for that. One is that ICWA protects children's rights to their families and their communities. And this is critical because it provides, the statute provides a higher standard that prevents removal of children from their families. Number one, by requiring, for example, the use of a qualified expert witness who must testify as to whether children are at risk of serious emotional and physical harm prior to removal from a relevant social and cultural perspective. So that's an important aspect of that. But that in addition to that, the statute also imposes placement preferences on state courts, requiring that children be placed with members of their extended family first. And if they're not available, then other families who are also members of that Indian child's tribe. And then, of course, the third preference, which is with other family members from other tribes. And then in addition to that, it's the gold standard because it requires active efforts to preserve and reunify families. And so this is in contrast to Title 40's reasonable effort standard. And so in contrast, active efforts is critically important because it requires, for example, that caseworkers work closely with parents to give them support services to help them access social services that may be available to them. So not just give them a piece of paper with a list of agencies and organizations with phone numbers, but actually work with them to help them make those phone calls. And so the active effort standard is incredibly helpful to preserve and reunify families. And then in addition, ICWA is recognized as the gold standard because it values inclusive and diverse cultural practices. And so that's partly also reflected in the use of the qualified expert witness who must be an expert as to the social and cultural practices of the tribe. And also the regulations require that jurisdictions that apply ICWA, they must reflect and apply the social standards of Indian communities. And then fourth, ICWA is also recognized as the gold standard because it requires authentic engagement with tribes. And so specifically, tribes, of course, have the right to participate in all hearings. They also have rights under the statute to transfer jurisdiction to tribal court And sometimes that tribal jurisdiction is exclusive. If the Indian child is domiciled on the reservation, it's exclusive. And in addition to that, it's important to note that when tribes are actively participating in the case, there's greater protection, and there's another concerned party that is working to protect the interests of that child. And so for all of these reasons, ICWA is recognized as the gold standard.
Thank you.
I'd like
so-
to add, I'd
oh.
like to add to that
Sure.
gold standard,
Bill.
and that's that ICWA is about doing best efforts at helping heal the problem that brought them into the system. And again, social sciences recognizing the intergenerational effect of foster care, that the odds of you ending up in prison or that your children ended up in foster care are increased with the fact that you were in foster care. And so by the time I left the bench, we received second, third, fourth generation kids, which meant we didn't do a good job help with their great-grandparents, their grandparents, their parents. What makes us think it's going to be any different? I mean, that's the layman's definition of insanity. You do the same thing and hope for a better result. ICWA was about doing something different to try and heal, to try and fix that problem so that their children won't end up in the same situation. So it's not about treating all people equally badly, which is what I interpret the lawyers asking for, but instead saying, how do we treat this child the best way we can for success, and then learn from that so we can treat every child the best way we can for success.
Thank you, Bill. So I'd like to go back to Claudette and continuing this discussion of the gold standard. So Claudette, can you tell us what you thought, or if you thought the gold standard was addressed during the oral arguments, and what can you share today about how ICWA works to promote the best possible outcomes for children and families?
So in general, in terms of practice, I feel like there wasn't that much actual practice addressed other than active efforts are a pain. And I want to follow that up historically with the notion and the reminder that active efforts in the history of child welfare actually precede reasonable efforts historically. Active efforts was in the Indian Child Welfare Act. Reasonable efforts became part of the statement, as Wenona mentioned, under Title 4E, which was established under the Adoption Assistance and Child Welfare Act of 1980. It's not a part of CAPTA. It's a part of ACWA. So the notion of reasonable efforts is actually a later addition to the game over active efforts. So I want to be clear on that part of the history. But in terms of how practice was described, and also in terms of use of evidence in relationship to ICWA, there were a lot of things that I felt were presented as evidence or as data in this that were actually not accurate. And I want to begin with McGill. If there is a person who said more things out of their mouth in the first 30 seconds that I've ever heard that could have angered me more, it was him. Beginning with, there are 11,000 American Indian children in foster care. First of all, let's stop right there, because that is not based upon political identity, and it's not even close to accurate, because that's drawn from AFCARS, the Adoption Foster Care Analytic Reporting System 2020, where Indian status and being American Indian or Alaska Native is totally based on race. It is a combination of either self-report or worker report. It has nothing to do with political membership whatsoever. And furthermore, that 11,000 is only the kids that are federally demographically recognized as American Indian only. It does not include the children that are 2 or more races, of which one of which is Indigenous. That number is actually probably closer to 27 to 28,000 rather than 11,000. And the reason why I bring this up, even though it sounds like, well, this is actually worse sounding than McGill actually said, is because we need to start incorporating the idea that every single child who comes into AFCARS should have been the target of an ICWA notice. Every single one of those kids there should have been something sent to a tribe that this kid has entered care. Every single last one of them. And then you let the tribes inform the state, is this child protectable under ICWA or is this child not? We don't actually know how many racially American Indian identified children are protectable under ICWA in the United States. The best estimate, it varies from place to place. The only place that I've ever seen that has looked at this is a study in California in 2010. The estimate's between 37 to 40%. I can tell you in Nebraska, where I'm at, the estimate is roughly the same, 40 to 45%, maybe a little bit higher. But the point is, all of those kids should have triggered a notice to the tribe anyway. Furthermore, all of those kids are potentially future citizens of a tribe today, whether they are currently citizens or not. And that's because tribes have the right to change citizenship whenever they please. So I have always been of the opinion that we should not be protecting Indian children only at membership. We should be going all the way down through CDIV status. That's always been my personal notion. But I want to begin by saying that that number is actually not accurate. Further complicating this, as I mentioned, is the fact that there is no mechanism of collecting ICWA data anywhere in federal guidelines or federal monitoring practices. Zero. In fact, the Department of Health and Human Services and the Department of the Interior are still fighting over whose responsibility it is to actually monitor ICWA compliance. So what we know is based upon generally small scale studies that have been undertaken by people who are deeply committed to this work. These are people historically like Terry Cross and Eddie Brown and Priscilla Day at the University of Minnesota at Duluth, and Angelique Day and some of her work up in the Puget Sound area. But the reality is we don't have too terribly many good large scale understandings of what happens to American Indian children in the system, much less whether ICWA works or not. And I would argue that by the fact that this has been a non-operational mandate as far as monitoring goes, that the federal government is complicit in the silence. As I am the publisher of if not the first, one of the first ever attempts to look at American Indian kids in AFCARS. I published this article in January of this year. AFCARS has been in place for much longer than that. And we've been doing research on AFCARS all this time. So, the question of do we know ICWA works? Well, first of all, my question is, how are we defining how ICWA works? Because if our strategy is using only what happens at the individual level of the child, especially since we already have a problem in national child welfare data collection about not actually collecting child well-being measures in the first place, and just assuming that meeting policy benchmarks is an equivalent of measuring child well-being, which it may or may not be, then there's that whole question to bring up in general. But I mean, the reality is we don't even understand what happens to American Indian kids when they enter the system. We don't have a way of not only measuring what happens at the individual level, we also don't have a good way of measuring what ICWA was supposed to do, which is protect and preserve Indian communities and tribes and bolster and empower them. So depending upon how you want to measure does ICWA work, the answer is either we don't know or we really don't know, depending upon which indicator. And again, it's part set up because the federal government has not facilitated any really good means to do this research. Now, I can tell you from what I'm doing currently in Nebraska, the study that I'm doing in Nebraska, without tooting my own horn too much, if not the largest scale, it is certainly one of the largest scale policy analyses of ICWA implementation and compliance ever attempted, if not the largest. And I can tell you from right now that we have good evidence that ICWA does work as far as its foster care components, because we're looking primarily at foster care, in reducing length of stay and getting kids home or in permanency sooner. And I am working on publishing, we're working on writing that up right now. And the reason why Nebraska is so important and relevant to this conversation is because many of the practice standards stated explicitly in the Nebraska state statute are either strongly influenced or were highlighted in the federal regs in December 2016, particularly around the implementation of active efforts. The Nebraska statute spells that out explicitly in practice in a way that no other state statute does. And I would argue that this is a unique opportunity and that we're taking advantage of this is an attempt to study and demonstrate that perhaps these practices work, even if they're about ready to be ruled unconstitutional. But again, Nebraska got there because they deliberately put themselves under a mandate by passing a state ICWA statute that has more teeth than the federal statute, based upon a commitment from the community and the Nebraska unicameral and the tribes to preserve tribal communities in the state of Nebraska. And so far it appears to be working. Preview of coming attractions, look for more information down the road. But as far as like actual, the reality is we don't know, in large part because there's never been a mechanism implemented to actually gather evidence other than a small handful of people on small scales, whether it be, St. Louis County near Duluth or Maricopa County in Arizona, to actually do that work.
Thank you. So now I'd like to ask if any of our other panelists would like to address the question about how ICWA is working today and if the court adequately explored that.
I'd like to address that because I was very concerned about the focus of several of the conservative justices on the third placement preference, where they seemed likely to find that Amy Coney Barrett, for example, said, well, doesn't the third placement preference just treat all tribes as fungible? And seeming to cast doubt on the fact that an Indian child's political status might have any relationship to another tribe. And I think that Ian Gershengorn on behalf of the tribes did say, well, we think it's probably really unlikely that these are placements that of Navajo children from Arizona that are being placed with tribes in Maine, for example, but didn't have any kind of data to back that up to show, when the third placement preference is applied, that And in fact, it's not so remote. And for example, I'm just thinking about the context in Michigan, for example, where we do have tribes that are part of the Three Fires Confederacy. They're all Anishinaabe, 12 federally recognized tribes. And our tribes absolutely have very close political relationships with each other in that they're signatories to the same treaties with the United States. They share a similar history of treatment of forcible assimilation and other Indian policies that have been applied to all of the tribes in Michigan. And furthermore, the tribes, of course, have a lot of intermarriage, and we also have similar cultural practices, similar language, and we have family members who qualify for multiple tribes. So, for example, while I'm enrolled at Little Traverse Bay Bands of Odawa Indians, I'm also eligible for enrollment with the Little River Band of Ottawa Indians. And while Matthew's enrolled at Grand Traverse Band of Ottawa and Chippewa Indians, he's also eligible at the Pokagon Band and at the Gun Lake Tribe in Michigan. And so our children theoretically could enroll in any of 5 tribes within the state of Michigan, of Michigan's 12 tribes. And that's not unusual. Our tribes absolutely have very shared experiences, and that's based on the fact that they do have a similar history of political treatment, and they do have unique political relationships and connections with each other. And so I just thought that there needed to be some context that I wish had been provided to the court when they seem to treat the third preference as being just sort of an outrageous race-based preference rather than truly based on political status.
And when I teach child welfare, and I'm glad, Wenona, you brought up the Anishinaabe example, because I was going to go there precisely because there are all sorts of arrangements among the Three Fires that if you're eligible for memberships in various ones, you're eligible in memberships for others, and it's very complicated. That also happens among the Ashanti-Sakowin out in the high plains with Cheyenne River, Santee Sioux, Oglala, Rosebud. Most of those tribes also have similar kinds of arrangements and relationships as well. So yeah, they're not, it's 574 tribes, but they're not discrete. They're not, there are 9 different Potawatomi nations. We have shared history. There's shared history and sometimes not shared history. And, it gets very complicated. But yeah, that fungible discrete notion, it's just not there. And so, yeah, that's, but, it's like when I teach people about serving notice, if you ask a family, well, what's your tribal background? Oh, I'm Sioux. Well, that means that technically you need to be sending notice to the Rosebud, the Ogallala, the Cheyenne River, the Standing Rock, Santee. If you say that you're Chippewa, then you'd better be sending notice to everybody from Little Shell and Rocky Boy all the way back to Seg Chip. And frankly, if you really want to do due diligence, you'd better be sending also to all of the Odawa and Potawatomi tribes while you're at it. So it's not as neat and discreet and neatly tied up with boundaries like we think of Western European countries. It's not that tidy. And anybody who does any work at all, no matter how surface in Indian country with tribes, with child welfare, recognizes very quickly that it doesn't take long for this to get exceptionally complicated in ways that were not done justice by the court.
Another way to look at it is that in many Native communities, your relatives are not confined to just who your blood related to. Your relatives are people who you share experience with, as Claudette was talking about, who you share a political background with, that Wenona was talking about, that you share an outlook on the world. And that makes you much more likely to foster and protect that with children. as opposed to a stranger who comes in, even with a good heart, and says, I want to do what's right, versus somebody who says, I share that with you. I'm going to help you find your roots. In the meantime, we have share these things. So the Native view of relatives goes beyond just nuclear family, goes beyond blood, extended family, goes to people who share our view of the world.
Thank you, Bill. So the second CLE passcode is family. So now we'll move on to our fourth question, which is about waiting for the decision. Many of us are wondering what will happen if ICWA is struck down. And this question, we're going to start with Bill. In your opinion, what can advocates, academics, researchers, practitioners, and other professionals who believe that ICWA furnishes vital protections for Indian children and families do if this happens?
Well, I appreciate the sky is falling question. If commandeering is the axe that the Supreme Court chooses to wield, the answer to that is relatively simple. Every state that has an ICWA in state law counters the commandeering argument. But there's also an equally simple answer in the federal system, and that's that we tie 4E funding that every state gets with compliance with ICWA. Now the federal government is funding compliance. That solves the commandeering problem as well. This separation where tribes and ICWA were separated out from 4E is an unnecessary complication. And I think Congress could relatively easily and even possibly administratively through the executive could resolve that to say ICWA compliance will be one of the measures that we look to for whether or not you qualify for 4E funding. The harder question is if if the Supreme Court chooses to wield the axe of race and equal protection. If they do that, potentially those people who have been funding these challenges will succeed in eliminating tribes as political entities so that they no longer can influence mineral extraction, water quality, pumping for oil, natural resources. Those are the interests that have been funding these attacks. So it's less about children and more about tribes as political entities. If they succeed in using race as the axe to cut away ICWA, I think you then start to urge states to adopt active efforts for every child, which is really what Congress, I think, intended when they passed ASFA. The legislative language, the legislative history that goes into reasonable efforts, Congress made clear that they did not want the status quo. They wanted to make sure somebody was genuinely trying to help these families, not just running through the motions. That's what active efforts was. We could start to define community and extended family preferences in both state law and federal law for everybody, so that if you had ties to the child, you had ties to the family of the child, that those would get a preference as opposed to a stranger. That lessens the traumatic impact on the child, that they're not going to somebody who doesn't speak the same language, who doesn't share a culture, who doesn't share a worldview. If we're talking about lessening traumatic impact on kids, we ought to be doing that again for every child. ICWA has really been sort of the pilot program for how we ought to take into account these extra considerations, where it's not just, can you feed me? Do you have a place to sleep? But do we share a language? Do we share a religion? Do we share their worldview? So we start to match the needs of the children to the prospective placements, whether it's for foster care or it's long-term permanent placements. And then I think we can start to identify successes in tribal communities and say, here are examples of how it ought to be. So for example, there's a program in Southern California, consortium of 7 small tribes. 15 years ago, they had 487 kids in foster care. Today, they're in single digits. And they did it by not pursuing 4E money, which is tied to foster care and removal, but prevention and helping families heal. There's a tribe in southern Utah that's had a successful placement rate of children within their community that exceeds 95% for 7 years. And all those cases are in state court. So it's a matter of saying the tribe has a different way of doing these things that states can learn from. So that's one of the things that upset me was during this argument, the assumption of a lot of the questions from the justices was these poor kids are going to be faced with life in Indian country. How can we save them? Well, in fact, there are aspects of Indian country that we ought to be sharing with other people because the kids will be better off. If we go further and say, okay, how do we deal with if this is the first step in abolishing tribes? So instead of a congressional termination, this becomes a Supreme Court termination era. Then you start to look at things like empowerment zones, where we do things for special tax purposes and economic interests, other things. So we sort of say, these communities of interest, of historical interest, of cultural ties, of worldview, are entitled to special protections. We do that for coal, we do that for salmon, we do that for water. There's no reason that we couldn't create empowerment zones to reflect tribal values. ICWA for all, and then one example in Michigan is we're building resilience courts. We're building courts that focus on healing, not compliance with a plan. So we're educating judges about trauma, about what resilience looks like. Then we're training them with motivational interviewing so they can actually have a conversation with the family and jointly work with the family to plan how do we go forward instead of just imposing things. That's very much the way tribal courts operate in terms of how do we reach these people for success? So we're trying to redefine success only as keeping children safely at home. Everything else is a prosthetic. Everything else is a second best. How do we help families succeed? And so we stop telling judges you succeed by following timelines, 15 out of 22 months, or you succeed in shortening cases. You succeed only if you can keep families safely together. And I'll get off my soapbox.
Thank you, Bill. Would any of the other 3 panelists like to address the what can we do question?
Sure. So I will tell you from my perspective in analyzing a state ICWA statute right now, that I do think that I think there's a power in state statutes regardless of what happens under ICWA, under BRACKEEN. A lot of it depends on what tribes choose to do. And I have not had a chance to look at the newest state ICWAs that have been passed, namely those in Oregon and New Mexico, in relationship to how they're defining certain aspects of practice. But I do think that defining active efforts in particular gives a lot of meat to these in ways that are helpful and useful. And so I think that there's a power, and it also shows a commitment between tribes and their state governments to bolster and support Indian communities in their practice. I think it's I hesitate to draw the metaphor to being a treaty we intend to keep, but I do think that there is at the very least a more open commitment to saying we want to find a way to work together around this. The state of Nebraska is one of the states with a very high racial disproportionality rate with Indian kids in care. And we're working very hard to try and reduce that. But I would say that as far as the state statute goes, Nebraska's is a really good one to look at, precisely because, first of all, knowing the history of how the statute was developed, it was collaboratively developed between tribes and legal personnel and a whole host of people who were conjointly committed to improving outcomes for Indian kids in the state of Nebraska. It was a very powerful collaborative process. And I think it's a really, it's a good model to follow. But I also would look at, it's great to have models, but I think coming to a table around thinking about how do we know that this is working well? And not just asking states so they can fulfill their guidelines. Let's say that we end up taking Judge Thorne's suggestion of attaching ICWA compliance to Title 4E. That's going to put a whole bunch of evaluation pieces in place that most of us have probably not thought of. I've thought about it just because of the work I've been doing in Nebraska. But the more important question for tribal communities is, how is this making us better? How are we coming together better as communities? How is this helping? Because one of the things that we say as Indigenous researchers in a space is that when we sit down to do research, we're not just looking to evaluate, did it work? But we're asking, is it healing us? Is it pulling us together? Are we becoming greater than we were before as the result of this work? Indigenous and decolonizing frames around research ask, in the work that we do, is this work making us better as a community? And that's the one question as far as ICWA effectiveness that we're not asking as readily. Probably the person who's doing, like I said, again, the best work around this is Priscilla Day. And I would love to know what the evaluation process is going to look like for the brand new children and families work that includes child welfare at Red Lake. I'm really going to want to see how they're evaluating that work, because I know it's going to be done at a communitarian level. How is it making, and especially with Red Lake, because Red Lake is a closed reservation, how is it going to be improving the health of that community? Because ultimately that's what ICWA is supposed to be about, is improving the health of the community and keeping it together, and keeping people tied to culture, to tradition, to kin, to family. So, we talk about what happens at the individual level of a child, but I'm going to be asking the question, what's happening with the community? How is this making us tighter and more committed to each other? And that's why some of the ideas that Bill has been talking about are particularly interesting, because you can't do that without a community deciding to come together in new ways to promote health and wellness. And in fact, health and wellness are not even terms that many Indigenous languages have. Dakota with Kohan or Minobimadizuin in the cases of Anishinaabe communities, those translate to balance, the good life. Excuse me. Those are what determines what health is. Are we balanced? Are we walking together? And that's the stuff that I think, yeah, safety for children is absolutely important, critically important. But at the same time, our child welfare process is making us healthier as a community. And that's a question we need to be asking in all of the United States across all child welfare domains and not just Indian domains.
Great. Thank you, Claudette. So I'm mindful of the time, and right now I'd like to transition to some Q&A, but in order to kind of accommodate everyone, I would ask that our panelists turn their attention to the Q&A box and answer any questions by typing your answers. And while you're doing that, I'm going to go over the wrap up housekeeping note thing. And hopefully we'll be able to accomplish two things at once here. So we would like to again thank our esteemed panelists for sharing their expertise with us today. I'm so grateful for the efforts you all put into bringing this content to our audience. We are so appreciative for the opportunity to deepen our understanding of how this case stands to impact child welfare services in our nation. I also want to again thank the staff at Penn Carey Law Conferences and Events for pulling this together, the faculty, staff, and students at the Field Center, in particular last year's Lerner Fellow in Child Welfare Policy, Nema Ali, who brought the idea of this symposium series on ICWA to our team and did a lot of the legwork to make it happen. Your last and final CLE passcode is CASE, C-A-S-E, if you're seeking CLE credit. So we have about 6 minutes, and I'd like to, let any of the panelists jump in, and if there's a particular question that has sparked your interest that you want to address, so everyone can benefit from your expertise and insight.
Well, if you don't mind, I'd like to answer the question about the Chief Justice's question about could Congress pass a law granting a preference to Indians on COVID vaccination distribution.
Awesome. Yes, thank you.
And the answer plainly is so yes. But it was a trick question. The Chief Justice was trying to force the government to answer a question applying an analysis that is incorrect. And the analysis that the Chief Justice wants the court to apply is to look at the bare text of a statute and ignore the reasons for the statute. And the way the Morton v. Mancarry test works is that you have to look towards a relationship between the trust responsibility and the act of Congress. The only way to do that is to look beyond the text of the statute. So it was easy. There's just a big long list of reasons why Congress passed the statute. And if Congress passed a statute saying we're giving preferences to Indians, so long as Congress said we've seen evidence, conclusive evidence that states and local governments are discriminating against Indians on the basis of their Indian status, then Congress has the power to create opportunities for Indian people to get preferences in COVID vaccination. This is actually a real thing, and I doubt the Chief Justice knows this. There were times during the height of the pandemic where the city of Gallup was doing a blockade on Navajo people in New Mexico from preventing them from leaving their reservation. And if they were trying to get to their reservation in order to get vaccines or access to healthcare, then that absolutely is state discrimination, totally justifies a vaccine preference. And that's the proper line of analysis. So that's my answer to that question.
Thank you,
Matthew. Thank you for asking it. Yeah.
Yeah, great question.
There was one question that got drawn as far as about the ASFA guidelines and ASFA deadlines. Yes, there is actually an active effort right now going on to repeal the vast majority of ASFA, including the timelines. and part of that is precisely because Indian children, as well as others, have been impacted by the ASFA guidelines. I am personally of the opinion that the ASFA guidelines were drawn and developed through a misuse and misunderstanding of attachment theory in ways that are inappropriate. I think the notion of trying to get these, get families to get their stuff together in 15 to 24 months with things that have, in some cases, taken generations to get to where you're at is a little preposterous. But there are some very active movements right now taken by people that I don't want to publicly expose, but the names would probably surprise you, to actually try and repeal ASFA right now. I would recommend, if you want to look at some perspectives on ASFA and its repeal, look at the first issue of the Family Integrity and Justice Quarterly, which is part of what Jerry Milner is doing in his post commissioner work, having now stepped down from his position at ACF.
Thank you, Claudette. Anyone else want to jump in with in response to a question and Q&A with our last 2 minutes?
I just want to say that BRACKEEN highlights the people who are challenging ICWA, but there are a lot of non-tribal agencies, funding sources that are supporting ICWA practice because it is best for kids, and they're reviewing it as a laboratory to learn so that they can then apply that to their own populations. That program I talked to you about in the San Diego County, San Diego funds a couple of those tribal positions because it reduces their caseload and it's a learning lab, so that the tribe is applying what they consider my two aunties approach. In tribal communities, your auntie is somebody who will put their arm around you, feed you, wash your clothes, make sure you have a place to sleep, but yank your ear and shake their finger in your face if that's what you need. But the goal is success. The goal is to help. And that's what they've built their program around. And to their credit, San Diego is supporting them in doing that because they're producing the results that everybody wants, which is keeping kids home safely.
And
Hey.
I would add that relative approach is what's being handled, is how it's being done at Red Lake. They've changed their entire child and family services to a name that from the Anishinaabe language translates into uplifting our relatives. And it's fundamentally based upon the premise that everybody who comes in is a relative. And the notion of the objective worker who remains unbiased is gone in a lot of these incubator hotbeds of Indian child welfare and child welfare practice reform that are taking place in reservations. And it's because in tribal communities, everybody is a relative. Because, kin networks are wide and vast and varied and far more endogamous than most white European kin models. So, and that's the reality, is that, having been trained in the old school way of not being, not getting too close. In fact, we're ethically obligated, and we can have a whole conversation in social work about whether our ethics obligations are too white and whether they're indigenous or not. I would argue that they're not indigenous. But that's really the secret that I think it comes down is, do we have a social contract that sees all of us as rising and falling together? And, I think ultimately that's where we have to get to a point of not just for Indian child welfare, but for child welfare reform generally in the US.
Thanks, Claudette. So thank you again to all of our panelists. It was our pleasure to host this discussion, and I invite all of you to join the Field Center for our future community symposiums. We hope everyone enjoys the remainder of their day. Thank you.